Good afternoon, this is Sean Golding with Golding & Golding, here to discuss a little bit about how tax treaties work with respect to FBAR foreign bank and financial account reporting, specifically regarding a post we had written a while ago and a current case that is pending about how treaty rights may impact FBAR. So just to make sure you're in the right place, FBAR, foreign bank and financial account reporting. U.S. persons, which is more than just individuals, it includes individuals, entities, trusts, estate, things like that, that have foreign bank and financial accounts that exceed more than $10,000 in any given year, they have to file the FBAR. It's electronically filed. Technically, it's called the FinCEN Form 114. It's not an IRS form, although since I think it was around 2001 or 2003, the IRS is tasked with enforcement. It's due on April 15th, but it's on automatic extension. It includes reporting bank accounts, investment accounts, pooled fund accounts like mutual funds, CCOBs, and ETFs, pension plans, and life insurance. Okay. People don't like having to file the FBAR because it's personal information, right? That's your financial account information. Likewise, if you don't file it timely, the IRS has been known to issue some significant penalties. There's currently a big case at the Supreme Court right now. It's called Bittner, regarding just how far and obnoxious the IRS can be when they issue penalties. When it comes to treaties, the U.S. has entered into about 60 international income tax treaties. There's lots of other treaties as well, totalization agreements, gift and estate tax treaties, things like that, but income tax treaties, okay? The IRS has stated in their practice unit, which came out, I think it was October of last year, as well as publication 5569, affirming their position, which is the following. You cannot claim treaty election benefits in order to avoid FBAR. So a green card holder decides to go back to their home country, let's say, or a different country to work, and they have significant contacts. There's different tests that you pass, and you go, okay, there's a treaty between the U.S. and this country. I want to be treated as a non-U.S. person for tax purposes. So you wouldn't have to report your worldwide income similar to someone who's a U.S. person, maybe file a 1040 NR instead of a 1040. Now, if you're not considered a U.S. person, does that mean that you don't have to file the FBAR? Well, the IRS, they don't want to play with this. They say it doesn't matter whether you make a treaty election to be treated as a non-U.S. person for tax purposes. That is not going to impact your requirement or your obligation to have to file an FBAR. There's currently a case pending right now, though, which is trying to take the position that if you are not considered a U.S. person for purposes under a treaty, and therefore you don't have to report worldwide income, then you shouldn't have to file the FBAR, which is a good argument, right? If you're not considered a U.S. person for tax purposes, why would you be considered a U.S. person for FBAR purposes? In fact, if you want to do kind of like the converse, if you're a non-U.S. person and you make a treaty election to file jointly with your U.S. spouse, you're not considered a U.S. person for FBAR purposes. So it's a really important case. It talks a lot about Title 26, which is the Internal Revenue Code, Title 31, which is Money and Finance. The reason that's so important is because the FBAR is handled under Title 31, not Title 26, but the regulations kind of go back and forth between 26 and 31, and so it's an important case. FBAR is important. We have lots of free information available on our main website and our sub-websites. If you're out of compliance and you want to get into compliance, there's various programs available to you. There's the voluntary disclosure program, which is for people who are willful or just can't certify under penalty of perjury that they're non-willful. Otherwise, you have lots of different non-willful options, the streamlined procedures, domestic and foreign. Both for offshore accounts, it's just domestic means you're not a foreign resident. Foreign means you're a foreign resident. It makes a difference because foreign residents don't get penalized at all. You also have the delinquency procedures and reasonable cause. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate to your matter, something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.